All rise. The Court of Appeals Division 1 is now in session.
Thank you. You may be seated. We're here today in our case number CV 240628, Slawson versus Slawson. Judge Payton is not feeling well today. She has conferenced the case with us, and she will be watching the argument and has given us some questions that she'd like us to ask. So she will be participating in the decision, but will just not be here, obviously. Each side will have 20 minutes to present your argument. Appellant will be responsible for reserving any time you'd like for rebuttal. These proceedings are being audio and video recorded. We'd appreciate it if you would identify yourself and your client when you begin. It makes it easier for those listening to the audio recording. We have conferenced this matter. We sent out some questions that we'll probably follow up on. But with that, counsel, you may begin.
Good morning. May it please the court. My name is Taylor House, and I represent the appellant, Matthew Slawson. I'll start by addressing the jurisdictional issues that were raised by the court in its April 30th order. The threshold question is whether the marital settlement agreement should be viewed as a court order or an independent contract between the parties. Our position is that the MSA cannot be viewed as an independent contract because wife never signed the MSA and never signed the decree. If you look at the decree in the MSA at IR 48 and 49, you'll see that both of those documents were only signed by husband. The way the decree got entered was in November 2008 at IR 42. Husband lodged the decree in MSA, and in that notice of lodging, he stated that counsel for wife indicated that she could not secure the signatures of her client on those documents. The decree and MSA that were subsequently entered in January 2009 were only signed by husband and his counsel. Although the decree was captioned as a consent decree, the court could not have entered a consent decree without mother's signature or wife's signature. Consent judgments are governed by Rule 45, which states that both parties must sign the consent and judgment before a notary or before a clerk. Here, only husband signed, so the court could not have entered a consent judgment, even though it may have been captioned that way. There was a memorandum decision issued last year.
Counsel, let me ask you before you get to that. You're talking about documents that were signed in January of 2009, right? And your point, as I hear it, is that they are not as they appear to be, and that a marital settlement agreement isn't enforceable as a separate document, even though it absolutely states that it is. Was that ever raised with the Superior Court in the last 15, 16 years?
It was never raised with the Superior Court, and it was not raised by wife in this appeal, that the court did not have jurisdiction or that it was should be viewed as a separate contract.
So there's been litigation about these two documents over the past decade and a half, and that point never sort of came up?
No, it never came up.
I take the record, we take the record as we find it, but that seems kind of awkward at very least.
I would agree. The determination of whether a separation agreement has merged within the decree, we have to look at the intent of the parties and the intent of the court.
And the intent of the parties, at least as I read the documents, and that's where we would start, right, was clearly it was not to be merged.
There is a non-merger clause in the marital settlement agreement, but if wife never signed the marital settlement agreement, I don't think the parties could have intended for that to survive as a separate contract.
Years ago, and no one challenged it. Wouldn't we be left with We have a non-merged contract that's not part of that should be pursued separately as a contract claim as opposed to a claim within the.
If the decree was, and marital settlement agreement were lodged and then adopted by the court, I think it can only be viewed as a court order. And that non-merger clause in the marital settlement agreement would be ineffectual.
But if we look to the intent of the parties, at least as to your client, he clearly didn't want it to be part of the decree. It was not to be merged. He signed it.
He signed it, but if wife never signed it, I don't think you get to I don't think there can be a contract. And the only other option is that the court entered it as an order. So even though he signed it, it was lodged and it was adopted by the court as an order.
Well, it was adopted by the court. We know it. It was filed. It was referenced in the decree as a non-integrated portion of the decree, at least if I recall the decree correctly. The parties have agreed to a division of community property and/or debt as evidenced by their signatures on Exhibit A attached here to and incorporated into this decree. Turns out there weren't signatures plural. It was signature one. Does that cast shadow on the validity of the decree?
I would argue that the language in the decree conflicts with the language of the marital settlement agreement. The language in the decree states that the marital settlement agreement is attached to and incorporated into this decree. I think that statement suggests merger. On page 5 at paragraph 13, the marital settlement agreement is referenced under the heading Other Orders, which indicates that the marital settlement agreement is an order rather than a separate contract. Under 25317D, when a separation agreement is presented to the court has two options. The first option is merger, and the 25317 says the separation agreement shall be set forth or incorporated by reference in the decree, and the parties shall be ordered to perform them. The second option is non-merger. It says the decree shall identify the separation agreement as incorporated by reference and state that the court has found the terms as to property disposition and maintenance not unfair. Under that second option, non-merger, the court doesn't need to order the parties to comply with the marital settlement agreement because it exists as a separate contract. Here, I think the court ordered the parties to comply with the marital settlement agreement. So I would say that the language in the decree conflicts with the marital settlement agreement.
That's one way to read it. Another is that the decree talks about incorporated, not merger, and the MSA clearly says not set forth or merged into any decree. So, I mean, there are arrows pointing the other direction. Wouldn't you agree?
There are, but I think the language incorporated into the decree suggests merger. If it said incorporated by reference, I think that would suggest non-merger.
How do you get there when the MSA says it's not merged? It's only incorporated. And the statute that you read talks about incorporation, not merger. In the second alternative, where if, for example, this was signed by both parties, you wouldn't make the argument that you're making now. It clearly would not be merged into the decree if it was signed by both parties.
I fully agree, but the fact that it wasn't signed by wife, I don't think you can have an enforceable contract.
And I think I'm with you there, but the next step is where I may not be with you. I'm not sure where that leads us. Here, 15 years later.
Well, I think the decree and the marital settlement agreement has to be viewed as a court order rather than a separately enforceable contract, which allowed the family court to exercise jurisdiction in an enforcement action.
Even though your client said that's not how he wanted it treated. And I get that from his signing the MSA, and the MSA says it's incorporated but not set forth or merged into any decree.
Yes, I think even though that language was there, the way the decree was entered procedurally, it can be nothing but a court order.
But nothing precluded your client from just filing a contract action, though, right on the, is there something that would have precluded him from saying we have a contract, she's not complied with the contract? I mean, and before leading you down a path in terms of jurisdiction, I just want to throw this out there. I'm only speaking for myself, not the other judges. Even assuming the court would have jurisdiction to consider a contract claim. It's one court, Superior Court can address the decree, can address a separate contract claim. So if the court had said, you need to amend the pleadings, the court has jurisdiction over a dispute relating to a contract, but a court doesn't have authority to come in and modify a contract. So if we view this as a contract claim, what would be your view of, if I were to say, again, not speaking for my colleagues, that you can't, the court simply can't modify a contract. This is a contract dispute between these parties. The court can't come in and say, I'm going to unilaterally change some of the terms of the contract. But wouldn't we be left with, we would have to send this back for a determination of what exactly the contract is? Have the parties modified the contract? What are the terms of the modification? How would you view that as an analysis?
2 points. Whether it's a court order or a contract, I don't think the court has the authority to go in on its own and modify the terms. Second point, you asked whether my client could have filed a civil suit for breach of contract. If he had done that, I think these same arguments would come up in that case. He would be trying to enforce a contract that wasn't signed by wife.
But would you be arguing that we could come in and impose, we could rule in his favor based on the record before us? Or is it something that would have to go back for a resolution of what are the terms that have been agreed to? Have there been modifications? What are the terms of the contract?
I think this court first needs to decide, is it a court order or is it a contract? If the court determines it is a court order, I think the court can rule on the record because the trial court properly exercised jurisdiction in this enforcement action. If the court determined that it was a contract, it may have to be sent back and a husband may have to amend his pleadings and the court may have to consider it as a contract.
You're saying under the first option we could rule in favor of your client if we view this as an order, and we could say the court didn't have authority to do that, and we must reverse that and say the court has to order that the house be sold and the property.
Yes, if it's determined to be a court order, then I think the court properly exercised jurisdiction, but the two orders, the 2018 order and the 2024 order, were still improper because they modified a court order many years after it was entered by the court, and I don't think the court can come in and modify a property settlement.
What's the remedy that you're seeking then?
Enforcement of the decree and the MSA. Because wife failed to refinance, this property should be sold and the proceeds should be divided equally.
You don't think there are any fact questions that need to be addressed about why it wasn't sold or whether there was some intervening agreement between the parties?
I believe those arguments were already addressed in Superior Court, both in 2018 and 2024. Wife's argument was, well, husband filed bankruptcy, so that prevented her from complying, and the court extended, on that basis, the court extended the refinance deadline 2 times. And as far as intervening agreements, the parties did testify about that at the trial court level, and the court considered that as part of its ruling. So I think those fact issues have been litigated at the trial court level already.
Counsel, let me ask you, it seems to me that the MSA, as from your perspective, could be treated as one of 3 things, either a separate freestanding agreement, you're saying it's not because it wasn't signed by both parties, and this may be like subpart of that first one, a Rule 69 agreement, and there weren't findings that were, or signatures and findings, and I think your argument is it's not that either. So doesn't that leave it as a decree alone, a court order? And then the question is whether the court could properly amend that on a request that it be amended, given things that maybe weren't contemplated in 2009?
The decree and the MSA should be taken together as a court order. Our position is the MSA was incorporated into the decree and effectively merged in the decree, despite that non-merger clause in the MSA. I'd like to mention there's a memorandum decision that was issued last year, Salcido v. Hamilton, where a similar issue came up. In that case, father lodged a decree without the mother's signature. Mother refused to sign for some reason. This court determined that the entry of a consent judgment was error. It shouldn't have been denominated as a consent judgment, but the parties nevertheless had a binding Rule 69 agreement, which the court adopted. This case presents a very similar situation, although it was captioned as a consent decree and marital settlement agreement. The trial court was just adopting the parties' agreements as part of its order.
When was the issue raised in Salcido? How was this years down the road? Was it?
It was raised after the decree. I believe mother appealed from the decree.
Right. So it was a timely appeal of a decree that then the court said there's a problem with, as opposed to an appeal in 2024 over a decree entered in 2009 that you're arguing there's a problem with.
Correct, but we're appealing from the enforcement action, and
the reason why I ask that is if you compress time, if we're on a timely appeal from the decree in 2009, you're saying Salcido would say we would have to vacate that decree, right?
I don't believe the court in Salcido vacated the decree for that reason. The court vacated the decree because it contained materially different terms from the Rule 69 agreement the parties had signed.
And the reason, and that may be the facts of that case, but I thought you indicated that it was lodged as a consent when in fact it wasn't, and that created a fairly large cloud over the decree.
Correct. This court stated in Salcido that it was error to call it a consent judgment, and I believe they said it wasn't clear whether the court intended to enter it as a consent judgment or whether which would have been error, or whether it was just intended to adopt the parties' Rule 69 agreement, which would have been acceptable.
But here, again, if my questions still obtain, it can't be a 69 because it wasn't cited by both, or wasn't signed by both parties, so it could only be a decree. So I'm not sure where that leaves us here in May of 2025.
There was an underlying Rule 69 agreement, I believe in September of 2008. There was a trial setting, the parties appeared, they put an agreement on the record.
Is that identical to the MSA or different than the MSA?
The minute entry does not contain the terms of the agreement, it just says it was recorded. And,
right. And you've been patient with my interruptions. What then is the relief that you seek today?
I think this court should find that the decree and MSA taken together are a court order, that the court had jurisdiction over the enforcement action, but that these two orders were improper because the court impermissibly modified the decree and the MSA to extend the deadline.
And by the two orders, you mean the 2018 order that was never appealed, and then the 2023 order that is
correct,
subject?
23-24.
How would we have jurisdiction over the 2018 order?
Well, you asked whether it was a final judgment or not. I don't think it could be a final judgment because it wasn't signed.
Okay.
So I don't think it became a final, fully resolved until recently when the Rule 78 order was entered.
Okay, thank you.
And I'd like to reserve the rest of my time for rebuttal if I can.
Thank you.
Thank you.
Your Honors, may it please the Court, Judge Catani, Judge Thumma, Judge Patton. This case just keeps getting more interesting. Al Arpad for appellee Catherine Slawson. This is the first I've heard about the decree and MSA not being valid because it's not signed, so I can't say I've researched that. I'd be happy to provide you with a memo after the argument if you think it's necessary.
Could you start with just addressing whether you think it was merged, the contract merged into the decree, or notwithstanding language that says it's not merged?
I think it clearly did not merge, and this issue wasn't really addressed by anyone prior to you all raising it, so thank you for raising it so we could make intelligent arguments today.
But if it's not merged, then what authority does the court have to change the term, to modify a term in the contract?
Well, it has the authority it would normally have under contract law, because there was a lot of testimony about the parties modifying their own agreement, which they're allowed to do with a marital
But is that what the
settlement
court did here? I was viewing this as the court just unilaterally saying, I'm going to extend the deadline to have the refinancing put in wife's name.
The court did not expressly address what jurisdiction it thought it was proceeding under. But I think the court's resolution is completely consistent with contract law, just basic principles, that parties are always allowed to modify a contract if they want to, and there's lots of testimony they did.
Did the court here find that the parties had modified and that I'm going to go with this modification? The modification is, I didn't see some sort, was there some agreement? We will agree to give wife X number of months or years to refinance. It seems like the court's authority, if not using the word jurisdiction, but the authority to say, this is what the parties have agreed to, and I'm going to enforce what they've agreed to. I'm not reading the court's order as saying, I find that the parties have agreed to an 8-year extension, and so I'm going to affirm that agreement. Am I wrong in reading it that way?
The court did not make those types of detailed findings, and nobody invoked Rule 82, so it wasn't necessarily required to.
But don't we need to, wouldn't we need to send it back to say what type of agreement? It seemed like the court was just proceeding on the notion that I have the authority under the decree to just extend the deadline for refinancing.
Well, husband's argument is that, no, you have even less authority to modify anything under a decree than you would under a contract. I think it's the opposite. He had a lot more ability to say, okay, this seems to be what happened. I'm going to apply some contract law equity here, and we're going to extend this deadline. Maybe the court came to the conclusion that the parties had never agreed to an express deadline. They were agreed they were going to wait a while.
Okay, but if that's the case, if the court came to that conclusion, how do we affirm doesn't the court need to make the decision, what was the parties' agreement? And there's all kinds of conflicting evidence. You've made a good case for why it should be extended under that the parties have reached interim agreements. But shouldn't that be a matter that's resolved by the Superior Court in the first instance?
Well, I think the Superior Court did resolve it. The Superior Court just didn't make as detailed of findings as we would like it to now.
But do you have some record support to show that this is what the parties agreed to? The parties agreed to an 8-year, or whatever the length of time to refinance. What's the record support for this particular ruling, as opposed to, I'm just on my own going to extend this deadline?
Again, if you were operating under statutory authority on Title 25, I think you would have even less authority to do that. But there are the testimony from the parties was inexact, as frequently happens in family court. And even if the trial court found that they were both making stuff up, he still could have found that the parties had an implied agreement by their conduct for 8 years to not do anything. And that's contract law. Again, there are lots of ways to approach this from a contract perspective. I absolutely cannot tell you which one of them the trial court thought it was doing, but this is not an order that the trial court did not have statutory authority to make under a contract analysis. So it's not a jurisdictional or quasi-jurisdictional shin type of an issue.
It's hard, at least for me, to hypothesize that the court's addressing it in that manner when it was raised as a request under the decree. It wasn't raised as a separate contract action, so it seems odd that we would attribute that to the Superior Court and say, it was addressing this as a matter of contract and concluding that this is what the parties agreed to.
I would be very, very reluctant to reverse trial court judgments based on a hypothesis that the trial court might not have been operating under the jurisdiction that it entirely could have been operating under and reached the same conclusion, if that makes any sense. And I'll give you the McCready case as an example. This is 168 Arizona 1. Okay, this is a family law case where years after the fact the parties came in and they asked the court to essentially assign a house to wife and give the husband an equalization payment, I think it was. And the court reversed that and it said, this isn't a Title 25 case anymore. This is now a partition case, and the remedies under a partition are very limited. And so the problem there is that it said the court did not have jurisdiction to enter the particular order that it entered. Unless the order goes beyond what it had statutory authority to do under the body of law that applies, I think you apply the normal presumption that you apply with a judgment that the court considered the things it should have considered and it followed the law and it made the findings it needed to make as long as they're reasonably supported by evidence. And I think that's what happened here. If we're going to
But
be...
you're positing that the court treated this as a contract claim when neither party raised it and said, this is what we have agreed to. This is the contract. It's not merged into the decree. This is a separate contract action, and these are the terms that we've agreed to.
I don't think either party raised the LeProd issue, either in the trial court or on appeal, and I don't have the slightest idea how aware of it this trial court was. And so if you want to write an opinion that says trial courts, particularly in family court, should think about that more because things get presented very informally, that would be a good thing. But reversing a case for lack of jurisdiction or hypothetical possible lack of jurisdiction because the trial court didn't explain its reasoning.
Even if we don't reverse it for lack of jurisdiction, if we just say we're going to reverse because the court doesn't have authority to come up with contract terms on its own, as opposed to interpreting the agreement that's been reached by the parties.
And I disagree with you on the record on that. I think there was plenty of discussion, and there are two prior hearings that you don't even have the transcripts of because the appellant didn't provide them, in which the trial court could have, for all I know, gone back and looked at that.
Two prior
testimony.
hearings from prior.
The 2018 hearing, you don't have a transcript on. And the trial judge in that concluded that this is modifiable for some reason that we don't know. And you would normally presume that that's supported by the record in that piece of the case.
Okay, so let me ask, today we heard that because your client didn't sign the MSA, it is, and I'm paraphrasing, so counsel don't be worried, you'll have the last word, but that this is not a contract, and at least as my paraphrase, not a Rule 69, so it's a decree. Looking at the face of these things, that's not the first conclusion I would have until I get to the signature page. But so did your client agree to these, the MSA, way back when? Or and I think your client didn't object to the entry of the decree with the MSA, you know, IR 48, IR 49, one to the next in the court file, and those have been there for 16 some years.
I have not had a chance to talk to my client about this to know what position she would like to take. You are absolutely correct. She did not object. I don't know of any reason to say she didn't agree. And again, I don't have the full record on whether this is a Rule 69 agreement, and I don't remember that if there was even a signature requirement in Rule 69 in 2007.
Well, it requires
so I can research those things if you want me to.
No, it requires us to get in the Wayback Machine, and I had injected that Rule 69, which in my mind is closer to a contract, but somewhere a little bit between a separate contract and a decree, but that's why I asked the question.
I think, having looked at it, that it's a contract, and I think that the trial court would not have had jurisdictional authority to go and excise some pieces out of it for the reasons Mr. House said, and then say, now I'm adopting it as a decree. So you'd have a problem there with whether that's even a valid decree at that point.
And I'm with you. we're 16 years later, and we're talking about what should have happened in January of '09, that to me casts at least a little fog, maybe not a cloud, but a little fog over the validity of a pretty comprehensive document that, as I read it, was intended to be a standalone contract.
And I suspect that there are procedural reasons why this is fine, because they adopted it in front of the trial court, and nobody objected to it for years, and they probably ratified it and probably missed their deadlines under Rules 83 and 85, if those even existed at that time. I don't remember. So I think the answer is going to be that the judgment is fine and that it should be considered in substantially the form that it was entered, even though it lacks a signature. But I haven't had a chance to consult my client, and I haven't had a chance to research it.
What was the reason for not refinancing before 2024? I assume it still has not been refinanced?
It still has not been refinanced simply because my client filed a motion saying make husband sign the papers, and the family court said, no, it's up on appeal, I'm not doing anything.
But why not file that 8 years ago or however many years ago, make my client or make husband sign these documents? Why the delay?
I believe the delay in both 2009 and 2018 was attributable to multiple factors, including the fact that the house was probably upside down at both of those times. There wasn't equity, and so refinancing, I doubt that my client was able to refinance without some loan-to-value equity there. There were various other things that came up as well, including the bankruptcy and so forth, and frankly, neither of these clients have expressed or have shown a particular inclination to go back and litigate everything. They went for years at a time without doing that because it's expensive and difficult, and they didn't know what the answer was going to be. That's the best answer I can give you on that.
But at some point, wife wants this treated as separate property and knows that there's a directive that it needs to be refinanced in her name only.
Yes.
And
I believe there was testimony that she tried to refinance before it came back to court. Husband was simply the one who filed something first.
But she didn't go into court to say, look, I need to get this refinanced. He's the impediment at this point. Please order him to.
She didn't go in first.
Okay.
I think we've hit most of the things about jurisdiction. Was there anything else you had a question on? I think you shouldn't dismiss the appeal for lack of jurisdiction, and I think it sounds like you've probably reached the same conclusion unless there's an obscure problem with the form of the decree back in 2009.
I do have a hang-up about the court's authority. You're saying the authority is it's resolving a contract dispute, even though the parties haven't pitched it that way. It has authority to do that. But
in virtually every post-decree dispute in the family court should probably be looking a little harder at that, even though hardly any of the parties are going to bring it up, because the parties don't know that it's a LaPrade problem. And even if they've got decently experienced counsel, they may not know that it's a LaPrade problem. So that, and
what's the point of putting it in saying this is not merged? I mean, at some point, our clients explain what the significance of saying it's incorporated but not merged?
I do not know. The only thing I know is that I've talked to counsel over the years who have different preferences on that for different reasons. Some of them think you should merge it, some of them think you should not merge it. Probably depends to some extent on whether you think you're the one who's going to be looking at the contempt remedy. I don't know. The one other thing I'll mention then is just that, as we said, the basic contract principles are there. The court could have concluded that they orally modified and that they agreed to be able to orally modify, even though the written contract said otherwise. We've quoted a case for that in our brief, I think. One who prevents performance of a contract may not complain of such non-performance. I think we cited a case for that in our brief. One we didn't cite was that if the parties don't agree on a time for performance, the court will imply a reasonable time. That's an old case, Zancanaro versus Cross. So if, in your hypothetical,
Here there was a specific date. I mean,
in the original one, yes, there was. We're talking about all the various modifications that occurred over the years. And by the way, if husband wants to argue there never were any modifications, well, then he's years and years beyond the statute of limitations on the original contract, if this is a contract. The only reason that probably wasn't raised is because everybody's arguing about what were the modifications that occurred much more recently. I think that's all I have for you, Your Honor, unless you have more questions for me.
Do not.
And again, if it's at all helpful to you, because I really don't think this case should be sent back if we can help it, I'll be happy to brief the issue of of what the original judgment is based on the paper record.
Thank you.
I'd like to emphasize the two things. The court cited to Rojas, in remarriage of Rojas, and to Scott v. Scott in its April 30th order. But both of those cases addressed a signed marital settlement agreement, and in both of those cases, at the trial court level, the parties litigated the issue of whether this is a contract that needs to be pursued through a civil action or an order that can be pursued in family court. So I think those cases are distinguishable for that reason. The court has to consider the parties' intent and the intent of the dissolution court in determining whether merger occurred or not. The parties' conduct in this case demonstrates that the MSA and the decree are a court order rather than a separate contract.
Counsel, again, help me better understand that. Your client has said, no, that's not the case, in signing the MSA. So I get your focus on intent, or at least objective manifestation of intent, which is what we're asked to deal with. It would strike me that that's mother's argument, not your client's argument, because your client agreed that it's not merged.
Well, if one party submits I view it more along the lines of a Rule 69 agreement.
And I injected that confounder,
Yeah.
and forgive me for doing that if it was not helpful, but.
Yeah, and the husband lodged the decree in MSA. The MSA included a provision which the court could not order, which is the non-merger clause. Without the agreement of both parties, unless there was a binding contract, I don't think the court could have ordered that the agreement not be merged. I don't think husband can unilaterally submit a purported contract to the court and have the court adopt it, and the court essentially binds both parties to a contract where one party didn't sign.
And I'm with you, but that's what your client did. And that's what the court did. And that's why I struggle. And I've got no pristine answer. This is a case where oral argument to me is very helpful, even though perhaps it doesn't give me clarity that I saw it.
Sure, but both parties have treated this as a court order for the past 16 years. And in 2018, wife went to court, never raised the argument that the family court couldn't address this issue or that it was a separate contract. And in fact, she sought and was granted affirmative relief in that proceeding, an extension of the refinance deadline, which again happened in 2024. So I don't think wife can come in now and say that that this should be considered as a contract or that the statute of limitations applies or that it couldn't be enforced. I think that's all.
Thank you. Thank you both for your arguments. We will take this matter under advisement and issue a decision in due course. But thank you for your preparation and humoring us by addressing the questions that we submitted. And with that, we will be recessed briefly before the next case. Thank you.
Thank you.